Good morning, Ms. Cowlow.
Good morning, Your Honor. May it please the Court, Ellen Cowlow, Deputy General Counsel on behalf of the Suffolk County Sheriff. It is the position of the Suffolk County Sheriff that it requests that this Court affirm what the lower court did, the trial court, and rule that the Department's compliance with a subpoena issued by a law enforcement agency, in this case the District Attorney's Office, seeking production of the recorded telephone calls of inmates and detainees is proper and does not constitute a violation of that individual's constitutional rights. Further, the sheriff would urge this court to find that inmates and detainees do not have a residual privacy interest in their recorded telephone conversations.
All right, so let's say you take these recorded conversations and you decide the sheriff really needs some money. So why don't we sell these personal conversations between family members involving some people accused of murder? So there might be some real interest in finding out what these people are talking about. Why don't we just sell them, put them on the internet, do advertising, raise some money? There's no privacy interest at all at issue here?
Well, certainly that would not be an appropriate exercise of the sheriff's authority as a law enforcement officer, and certainly it's not something that's consistent with the sheriff's department's policy of only providing these recordings in response to a lawfully issued subpoena. I would suggest that if these recordings happen to get themselves in the hands of folks from whom they should not, that doesn't necessarily mean that there is a residual privacy interest in these phone calls.
But is the sheriff barred by the Constitution, by any interest in privacy? Now that the sheriff has properly recorded them, are there any limits at all that are placed on the sheriff's use of this material? Any privacy-based limitations?
I'm not aware of a statute or a constitutional provision necessarily that would expose the sheriff to the kinds of civil liability that Justice Riley suggested in the DuBose case. And certainly that's not the use that's of concern here. The use that's of concern here is the Department's compliance with lawfully issued subpoenas.
Let me ask you a somewhat different question, because there can be lots and lots of lawfully issued subpoenas, and I think the question is, do you want to raise the issue of privacy at the get-go or at some other point? Let me say, for example, leaving Justice Cordy's question aside, if there is a civil dispute arising between somebody that's, I'm talking about plea trial now, not post-trial, plea trial, and there's a civil dispute that involves, something unrelated to the law enforcement, and a subpoena is properly issued because discovery is broad, and the party comes in saying, I think that there may have been a discussion about my case. Civil discovery is pretty broad. You could just about get everything if it exists. It could, so nobody questions the subpoena. It's lawfully issued. It may, somebody may have actually gone in to get a subpoena because the sheriff said, I'm not just going to take a discovery order. Is that an appropriate place to raise a privacy interest?
Well, several things. The Department does not listen to these phone conversations on a regular basis. So we are not aware necessarily of what is communicated between individuals.
I understand that.
Okay.
I understand that. So the Department, one defense would say, I can't tell you whether there's anything relevant.
Mm-hmm.
And, the person says, yeah, well, I understand that. Well, just give them all to me and I'll figure out what's relevant.
I think that when an individual engages in a conversation, which they are aware is being...
No. I understand that. But so would it be... It's a validly issued subpoena. Would the incarcerated person be able to object on the grounds that there are privacy interests here?
If that person was on notice that a subpoena had been issued for them. We don't inform these individuals that a subpoena has come in and requested their records.
Assume that
I would
the
suggest,
person has known.
not. No.
Well, then your answer to justice, forget about whether or not the sheriff can go make money. That's a
Right.
different thing. But essentially, for any purpose at any time, as long as in the sheriff's view, it's a validly issued subpoena.
That's
there are
correct.
no privacy interests.
That's
Civil,
correct.
criminal, pre-trial, post-trial, right?
Absolutely.
Okay.
And that's what the department should be able to rely on and comply with those subpoenas.
Okay.
If the recordings are made for security reasons, you just said the the sheriff's department doesn't listen to them. Don't you think, I mean, how do you protect security if you don't listen to these, at least occasionally?
Well, firstly, Justice Cowan, the inmates are advised that their phone calls are being recorded and are being monitored. They are not advised of what the purpose for that
No,
is.
but that's at least
Certainly.
ostensibly the purpose.
We do not regularly listen to the phone calls that are made by in excess of 2,000 individuals that are held in our facilities on a daily basis. We simply don't have the manpower. When the department is engaged in an investigation of either illegal conduct by an inmate, a detainee, possibly a staff member, allegations by the inmate themselves that they brought to our attention, then in
Then
the
you go back
context
and then
of,
you look.
in the context of that, we actually will listen. We may listen in real time, or we may listen later on after we've got the information and we're in the middle of an investigation.
And I take it, at least in theory, you can now get simultaneous searchable transcriptions of these, so that we could at least imagine that in the future, you know, if the department wants to, you know, let's say the allegation is somebody's bringing drugs in, somebody's bringing guns in, or I'm arranging for somebody to kill somebody outside, you could
Yes.
do a pretty focused search.
Absolutely, and that in
Okay.
fact has happened in the very recent past, in which there was information developed that an inmate or inmates were
No,
involved.
so the sheriff has very real interest in being able to do this.
Yes,
And for its security purposes, to determine what an appropriate search of those records is.
absolutely, and I think
Right?
that
And
this,
if you had the manpower and you sat there listening to 2,000, you would fend off an attack that says you can't do that.
correct,
Okay.
correct. And the security interests for the institution do not end at the four walls of the institution. There's a legitimate penological interest in deterrence, in the fact that the individuals are on notice that their phone calls are being recorded, and in fact, they may be listened to. That in fact, you know, the sheriff putatively may very well, not the sheriff herself, but the investigators are on the other end of the line. It is not a confidential phone conversation. It is not a private phone conversation. And that the interests of the department in maintaining their own order and discipline, ensuring the safety and security of staff and inmates, and preventing illegal conduct inside the walls as well as outside the walls is a legitimate penological interest.
Ms. Colo,
Colo.
thank you. Would it be fair to say, and I mean this, that the sheriff's view is, I have a right to record, all of these conversations, leaving aside attorney-client privilege, I understand about those. I have a right to record all of these.
Correct.
And my next thing is to make sure that I am not civilly liable to anybody if I hand them over. So what I do is I do a legal analysis that says this is or isn't a valid request, right? So, you know, court order is the best, subpoena is the second best, but you make a determination, and that's really what you're trying to do. In other words, you don't have any particular interest in what happens to them afterwards. Civil, criminal, doesn't make any difference to you, correct?
It is correct that we don't have an interest. What we don't, our interest is not exactly the same as the district attorney's.
No, no, I
think as a
understand
law
that.
enforcement officer, we have an interest in cooperating with other law enforcement agencies. But to the extent that these recorded phone calls may go, as you suggested earlier, in a non-criminal context, we have an interest in ensuring that when we receive a subpoena or a court order, that we are lawfully within our rights and we are not exposing ourselves to civil liability by complying with that.
So if a newspaper or television station or, you know, somebody else comes and says, I want to get access to these, you have some other concerns, namely whether or not the sheriff can engage in this kind of, whether the government can ever make any money. I mean, in a way, and I mean this with all, you know, sort of no different than, in that sense, than the registry of motor vehicles, right? You want to make sure that you're not opening yourself up to some untoward liability.
Absolutely, and that's precisely the reason why we took the steps to appeal the decision by Judge Connolly in the motion to quash, to make a determination that we were in fact operating appropriately when we receive a subpoena. I just want to clarify one point that you mentioned, Your Honor. The position of the Sheriff's Department is that we should not necessarily have to evaluate the quality of the subpoena, whether it's a subpoena, a trial subpoena, or a grand jury subpoena.
No, I understand that. I mean, but you will evaluate in the sense that if it doesn't look like a subpoena, I mean, you will make some minimal inquiry to say this is a valid subpoena.
Correct.
And then other than that, you don't care whether it's, I don't mean you don't care.
Understood.
But it is irrelevant for legal purposes if it comes from a grand jury, a trial, pre-trial, post-trial, court order or not, as long as you have made a determination that this is, in fact, a real valid subpoena.
That is correct.
Right.
That is correct.
Again, regardless of the use it may be put to.
Well, that's the position we find ourselves in.
Right.
Yes, we are custodians of these records. We have them in our possession. We routinely receive subpoenas. We need to know whether or not we
One of the problems is the only reason you are in possession of these is that you get a bit of a pass because of the peculiar nature of your function, which is to basically keep prisoners incarcerated pending their trials or for sentences, and their security needs that really require the monitoring of those, of conversations and communications. I mean, that's the only reason you have these.
That's the only reason we have them, but I'm not sure that focus on institutional security within the four walls prevents a barrier from that information being shared with other law enforcement agencies. We certainly only provide these recorded conversations in response to a subpoena. We may share information.
Okay, I'm sorry. Yeah, go ahead.
No,
finish the question.
We may, and our policy indicates that we can share information to the extent it's consistent with law enforcement purposes, public safety, institutional security concerns. The information contained, not the actual disk of the recordings.
Yeah, so I take it for sure. If you've come across some possible crime, you would obviously not need a subpoena to assist in the investigation of the crime.
No, we will proactively contact the appropriate authorities and provide that information.
But that is presumably not because you are law enforcement. That would happen in this court, for example. I mean, that has nothing to do with your status of law enforcement. It has to do, as it were, with your status as citizen or public entity, right? So that a private employer, a public employer, anybody else, if aware of, and there are countless examples of ongoing potentially illegal activity, would have no hesitation, I suspect.
No, none whatsoever, but I would suspect that the public would expect that the sheriff of a county who's responsible for maintaining, who's a law enforcement officer and responsible for maintaining security inside the House of Correction and the jail would have an obligation, even a greater obligation than the average citizen, to provide this information.
Sure. I mean, my problem, I just have a hard time viewing you. We are merely a custodian. We simply have this stuff. If somebody wants it, they send us a little subpoena, we turn it over, no matter to us. You have it for a very special reason. That doesn't mean you can't share it with law enforcement or can't even provide it. But does that just mean it's usable in any way and none of the parties whose conversations have been captured have any grounds to keep you from just distributing it around?
Well, these individuals, the inmates and detainees and the folks on the other end of the line, know from the beginning that this conversation is being recorded and may very well be monitored in real time. It is no longer private. It is no longer confidential. Afterwards, we are the custodian of these records. We get numerous requests. It doesn't seem... we are, in fact, the custodian of these records because we do not then go and listen to all of these recorded conversations unless we have an active investigation in order for us to make a determination about whether or not there's anything contained therein that's relevant to an ongoing criminal investigation.
So I say you're like essentially, well, assume you're a phone company and there's a little recording on the beginning of every conversation. This conversation may be recorded. So you're a phone company, have all of this stuff. But so you have no special obligation, there's no limits on what you can do with it. Just because people have given up their rights to privacy in it, and so it's your stuff.
They have no other way to communicate.
But they do, Your Honor. In fact, they have the right to write letters and to receive letters.
Are read?
No, they're not read. We are not allowed to read them. We check them for contraband. We are not permitted to read them. Legal mail is opened in the presence of the inmate. It is checked to see if there is contraband, if there's a weapon. It is then turned over. Furthermore, inmates and detainees are permitted to have visits with individuals in which they can communicate. They also can communicate with their attorneys. And I think that courts have said that, those other options that are available, readily available to inmates and detainees is one thing that courts consider when evaluating whether or not the restrictions placed upon the phone system are appropriate and whether the dissemination of that material is.
In some instances, and it's maybe not in your jail, but in some places, the contact visits are also by phone.
At the Suffolk County Jail, they are not recorded. So that is a way for individuals to communicate with family, friends, loved ones, associates in a way that is not monitored. I mean, there's obviously a necessity to monitor the telephone calls because they occur. So it's such an effective means for individuals to communicate about things that may involve, in fact, criminal activity.
I'm not arguing
Sure.
with that. It's sort of what happens to it thereafter. That was in that context.
I appreciate that, but I think that the court should be aware that there are other means of communication that are readily available to inmates and detainees. Inmates and detainees make a conscious and informed decision to utilize the telephone, knowing that the calls are going to be recorded, knowing that that they may very well be monitored, that there's a third party on the line, and that in and of itself, I would suggest, in any way minimizes or eliminates an individual's expectation of privacy, one that the public would be willing to accept.
When I read the briefs in this case, the sense that I was getting was that all the sheriff really wanted here is some kind of a ruling that would allow him to
That's true.
to comply. In lingering in that reading that I had is the concern that in some case in the future, if some third party other than a law enforcement or other than a defendant and co-defendant in a criminal case or something like that files a request for information or a subpoena, let's take a subpoena in another case, a divorce case, would you not oppose that with the same vigor that you're opposing this one?
I think I nailed that one, didn't I?
I thought you did.
She would not. As long as you had I'm not going to put the answer in you, but as long as you have satisfied yourself
If we've satisfied
that
ourselves
it's a
that there's a
probate and
subpoena.
family court that said,
The only instance I would suggest in which there may be pause is when there's a request for medical records, for which there's a statute, there may be statutes or there are statutes that apply to them. Then we may say, you know what, that subpoena's not enough for us, you need to get a court order. But for any other sorts of records that the department holds, when we have satisfied ourselves that the subpoena is legitimate, then we feel we have an obligation to comply with that. And we feel that we should, and it's appropriate.
thank you, Ms. Carlo.
Thank you.
Mr. Zanini, good morning.
Good morning, Madam Chief Justice. May it please the Court. John Zanini for the Commonwealth. The grand jury subpoena at issue is on page 10 of the record appendix. It includes visitor logs for a limited period of time, approximately 6 weeks. It includes phone call logs, and then it includes the recordings. So just so it's clear what the subpoena covered. The objection and the motion to quash just dealt with the recordings. But I don't believe any of the material sought by the subpoena has been produced. The sheriff's policies, Attorney Carlo mentioned, there are face-to-face visits that are unmonitored and unrecorded. There are letters that are uncensored. The sheriff's inmate guide is in the record appendix, starting at page 124.
I'm sorry, the show's what?
The inmate guide,
guide.
which talks about the visits and the letters. So that's also in the record by stipulation of the parties. I think once the sheriff is legitimately making these recordings, which the court has said the sheriff can do under the Kachiko case, and which every court in the country has said jailers can do, and once a party knowingly exposes their conversation to the sheriff is, for all intents and purposes, a party to the conversation. The sheriff is not merely the custodian of the records. These are the sheriff's records. They are not someone else's records that the sheriff is holding. And once the conversation is knowingly exposed to the sheriff, there is no privacy interest. Once the privacy interest is legitimately obviated, there can be no residual privacy interest. The
I
Constitution...
take it in the absence of a statute or that would, so you've got...
I would agree. And there may be some...
Or attorney-client privilege.
Yes, of course, and no one's recording
Mr.
attorney-client
Zanini,
calls.
let me ask you this. We had a case, you may recall, I think it may have come out of your office, that had to do with subpoenaing parents to testify before a grand jury. And I thought we had an elegant solution to it, but we haven't actually decided the issue. If you have parent-child conversations, does that make a difference?
No, because there's no privilege there. I mean, that's exactly what the court said, is that, there's
No,
no,
we didn't
there's no
say that.
privilege for the parent not to testify. My recollection is...
I don't think we decided the issue. I think we
Well, there's-
decided not to decide the issue and to leave it to the legislature, and nobody came back and asked us to decide it. So I'm pretty clear we haven't decided that issue.
Well, what you decided is there's no statutory privilege, so there's no basis to quash the grand jury subpoena. There's no basis for...
No, I think we decided that there was no statutory privilege, but that didn't mean to say there was no privilege. There's no statutory attorney-client privilege.
Well, there's no privilege. I mean, there's a number of statutory privileges.
No, they are.
None of which raise constitutional challenges. In fact, the court is pretty clear. There's a whole line of cases regarding rape victims and various statutory privileges, and I think the court, over a course of about 20 years, ultimately wound up at the position that there's lots of private information which is not protected by the Constitution.
No, I understand that, but this was a particular issue which had to do with a child talking to a parent.
Right.
And it seems to me that raises some concerns that are not present when you have an adult talking to an adult, even if they are familiar members. I'm just...
Right. I agree with the court.
Okay.
Well, I mean, I assume these may contain spousal communications.
They may, but again, any statutory privilege for a spousal communication, any communication in the world requires, of course, that the confidence of the conversation be maintained. And the minute you have a third party who is present at and part of the conversation, there is no privilege.
Okay, so
And
you're
the
saying
sheriff-
the only,
the sheriff
the
is a
only
party.
privilege, the only privilege that's respected is the attorney-client privilege.
Well, there are provisions for inmate religious visits in the inmate guidelines, and there might be other accommodations that could be possible. But you have a content-neutral rule, which is reasonable and which is designed to protect the security and order of the prison, to deter criminal conduct inside and outside the walls. And once you have a content-neutral rule, you have a reasonable
But you could make
regulation.
you could make the same argument about the attorney-client privilege. You could say, well, there are lots of opportunities. We don't read their mail. They can come and have visits. And so clearly something else is operating here.
That's the Sixth Amendment. That's the Sixth Amendment. I
Oh,
mean,
but
that's,
there's
that's
also-
the issue there, not a Fourth Amendment issue, not a privacy issue. It's a Sixth Amendment right to counsel issue.
I understand, but in the I think I'm correct that in the child-parent thing there was a Fifth Amendment claim raised.
I don't recall right now. I'm sorry.
Would you feel differently in terms of the limitations if there were no opportunity for unrecorded face-to-face visits and no opportunity for unexamined mail?
Well, that would go to the issue of whether or not the regulation, as it's implemented, the actual recording and monitoring of calls is reasonable, yes or no. So that's just one factor to weigh in the decision about whether or not the policy is reasonable.
I'm struggling with this, but I think it's the point that there may be, when you have a captured population, that you can't just look at it in terms of, well, you consented, you knew that these were going to be recorded, so you've voluntarily given up your right to privacy, and it can be used for anything. That yes, it can be used because you have legitimate penological interests to protect as far as jail security goes, but that's different from letting the district attorney come and use it for prosecuting you in this very case, which of course is not happening to anybody who isn't in jail.
But the fact that it's a different use doesn't mean that you somehow re-attain a privacy interest. Once you've knowingly exposed your conversation, your privacy interest is obviated.
Wondering whether there's some distinction, whether something should happen when you have no other way to communicate with
There are other
anybody
ways.
on the outside.
There's face-to-face
No,
visits,
that's
there's
why
letters.
I say, would you feel different if that weren't the case? Because I think in some institutions it isn't the case.
Well, the regulation might be struck down as invalid there.
Would it make a difference?
That's the problem with the underlying regulation and the underlying recording there, not with the sharing. Once you have the recording and that regulation is valid, then you can share it with any other government agency. You may not be able to publicize it to the world at large for
Why?
various reasons.
Why?
Because
Not the privacy right of but not the
There's
privacy
a-
right of the inmate.
That may be right, but there may be privacy rights on the person on the outside of the walls who's a party to the call where that kind of governmental disclosure might not be appropriate because we have public records laws, we have Chapter 66A, which deals with protecting data from disclosure by the government. We have a statute 214B1, which deals with an invasion of privacy type tort. So there may be other remedies for people, but none of which have anything to do with the Constitution, and none of which have anything to do with the Fourth Amendment or the 14th Amendment to the United States Constitution or Article 14. For
Mr.
instance,
Zanini, let me just ask you if I can, just to follow up Justice Botsford's. To what extent, I mean, in this case, I understand in this case that you can, A, write a letter, and B, the sheriff has determined that the sheriff in this case won't read the letter. And the sheriff has also decided that you can have visits, but as it happens in this case, and in this case, the sheriff has determined that those will not be recorded. What if, as a practical matter, and unfortunately it is a sad fact that many children, but also adults, can't, as a practical matter, read or write. And second, that they are in a situation where, as a practical matter, they can't communicate with their family members because either, the family member may be at the other part of the state or out of state, so that there are practical barriers. So the only means of communication are by telephone.
Well, if for instance, someone is transferred from Suffolk County Jail
Or to Texas.
Plymouth Jail.
Or to Texas.
Or to Texas. I mean, the
Or from
fact-
Texas to here.
Right, but I don't think the Constitution, I haven't really thought that through quite that way. I don't think the Constitution says that because they lack the economic resources to travel to Texas, therefore they're entitled to a different set of rules and regulations
understand.
than the local
Yeah,
prisoner
I was just looking to
with the
your
local
response to
family.
Justice Botsford that it depends whether or not the regulation is reasonable. I mean, I think what we have here is a clear recognition that these recordings are not only appropriate, but a necessary part of the sheriff's running of a safe institution. And so, for example, we would tolerate all kinds of things like, people may be searched, so on and so forth.
As long as they're equally applied to everyone, then I don't see any constitutional
But,
basis to
but
challenge.
I think there are some constitutional principles that say you may give it up for these purposes, but that doesn't mean to say that you've given it up for all purposes.
No court has ever recognized such a principle. No court that I can find anywhere has ever recognized this principle against once the information is knowingly exposed to the government, that somehow you're then protected against the dissemination. The court that comes the closest, I think, was the Nixon case, Nixon versus the Administrator of General Services, where the president tried to shield his materials from the archivists. And the U.S. Supreme Court, even there, they said, well, you just balance his interest in what there are undoubtedly some private conversations and private materials that an archivist will look at, but that doesn't mean that the archivist won't look. The archivist will look because there's a public interest in having all of the rest of the materials as part of a public record. So it's the same. At worst here, you get to the same sort of a balancing test where, gee, you're going to look at some of my private conversations, and the answer is, well, yes, but the public interest in the sheriff
No, that's
enacting
not-
the
that's-
reg and in the prosecutor and prosecuting.
That's not the issue. I think it's the use of them.
But that was a use. The use was There is a person who had to look at them, namely, in that case, the archivist, in order to make use of them. The use came after the looking, and the listening in the case of Mr. Nixon's tapes, President Nixon's tapes.
The sheriff has to look at them and make use of them, but does everybody else in the world get to look at them and make use of them for totally different purposes? That's a different question, isn't it?
The answer is not everyone else in the world.
What
The
about
answer is
what
the
about
grand jury, the police, or the prosecutor.
What about a FOIA request?
They may well be subject to disclosure as public
Well,
records.
that's the point.
Absolutely. Yes.
Well,
But
then
there is
that means anybody.
But there is a medical records exemption. There's a privacy exemption. But the privacy exemption under FOIA is to be exercised by the holder of the record, not by the person whose record it is. So the sheriff could waive the privacy exemption and provide the record to some other person.
Mr. Zanini, what's complicated here is that, these recordings aren't constitutional only because the parties agreed they got a warning in advance. That's not what makes them constitutional. It's that plus they are valid peniological reasons for their gathering. Those two things together make the recording of these conversations and presumably the preservation of these conversations permissible under Article 14.
Well, maybe not. So it could be constitutional without a warning. So if you look at the history of the federal wiretap laws, they don't prohibit it. In the history, there's a discussion, and they say, well, we're not talking about jail cells. So clearly you don't have a privacy interest in your jail cell. And that's pretty clear that you've lost most of your privacy interests once you've been detained by the government. So for constitutional purposes, the statement, by the way, we may be listening, may not be necessary. It still may be constitutional to listen. But you don't need to reach that issue because there's a legitimate regulation in place in which they are told. Once they are told and they choose to speak while being potentially listened to and recorded, they have waived all of their privacy rights. They have knowingly consented. They have spoken and knowingly exposed their conversation to the government.
But how can that be? If you've given up your privacy rights, does that mean that the sheriff can open the doors of the jail to the public and let them come in and watch the prisoners sleep or watch them eat or do those do very private things?
It's a whole separate issue. If someone discloses information to a probation officer, to a judge, to a parole board member, to a police officer, to any of these governmental actors, including the Registry of Motor Vehicles, we have never said, the court has never said that any of those governmental actors who now have information which was knowingly disclosed to them cannot share it with someone else because the purpose of that information was, I was just trying to get out from under probation. I was just trying to get a driver's license.
But interestingly, we do it all the time in cases involving certain kinds of privileged material, disclosure of certain kinds of protected business secrets. We permit limited disclosure for limited purposes, and once you get that, you can't just go out and give it to anybody.
Well, that's a protective order in a court of law, which is entirely different.
Why? Why is it different? Why?
Because there is no privacy interest at all in this conversation when the underlying regulation is legitimate, when you're on the phone, when you know you're being recorded, when you know the government has it.
But it's legitimate for a particular purpose.
No, it's legitimate. Once you waive, that's not the issue. The issue is if you have waived your privacy rights, or if the government has, forget waiver, if the government is legitimately in a place where it can listen to your conversation, you have no privacy left. And any member of the government who hears that conversation can share it for any legitimate purpose, at a minimum. Maybe not an illegitimate purpose.
It's a very scary
but at
proposition.
a minimum. It's not a scary proposition. It's the way, it's the Fourth Amendment. It's Article 14 as it's been for hundreds of years.
Okay, but do you
the
need
only
that?
distinctions?
I mean, in this case, the only question is do we hold the sheriff in contempt? And as far as I can tell, your argument is it's not privileged. It's lawfully subpoenaed. They refused. Hold him in contempt. Do we need to get to whether there's any privacy interest?
You must, because the only basis for the motion for contempt here is this supposed constitutional privacy
But
interest.
they haven't argued that.
And
The sheriff's not saying
that's
there's
the
a
whole
privacy
basis
interest
for the
here.
motion to quash.
Is the sheriff,
Only-
the sheriff is saying that there's a privacy interest here, and therefore our regulations in some fashion invade the privacy of the inmates, and therefore we can't give it over? I don't think, I don't hear that.
If you don't decide the issue, we'll be back again and again and again.
But we'll be back with somebody arguing against it. That's the problem here, is we have two sides saying the same thing.
Well, we're not, I don't think
done
we
yet.
are saying the same thing. That's why she filed a motion to quash, and that's why we opposed the motion to quash. Thank you.
Thank you, Mr. Zanini. Mr. Shapiro?
May it please the court, I am here to present argument on behalf of the amici who have filed a brief in this case. And on behalf of the amici, I thank the court for affording us this brief opportunity. The reason why it's important that amici be heard is, as Justice Gans just said, the 900-pound gorilla in the corner here is the interests of the John Doe whose telephone conversations were recorded at the Suffolk County Jail, as well as the hundreds and thousands of other John Does, the pretrial detainees in houses of correction and jails throughout the Commonwealth, whose telephone conversations are routinely recorded by the authorities. In this case, the district attorney is asserting a virtually unlimited power to search the contents of those telephone conversations of these jail detainees for the purpose of finding evidence to use against them in a criminal case.
Mr. Zanini says there are no cases nowhere that say, that being recorded for one purpose, which you acknowledged in the amicus brief, is legitimate from the sheriff's perspective. That there's no law that would say, therefore, you've given up your right to privacy and it doesn't get reattached to it for some other purpose. So what do you rely on for this kind of two-stage?
We rely on the law which says that a inmate or a detainee in an institution retains all of his constitutional rights only to the extent that they're not inconsistent with the legitimate needs of the institution. So an inmate, a detainee, retains his Fourth Amendment, his Fifth Amendment, whatever rights, except to the extent that it's necessary to curtail those rights in the interest of institutional or prison security. And that's what this court said in the Cachiccio case. The only reason that the DOC can record these conversations is that they have a legitimate penological interest in making those recordings to prevent crimes in the prison, to ensure institutional order and security. But beyond that, there is no justification, and neither of the parties here, the sheriff doesn't say that there's any justification in recording these telephone conversations with respect to any law enforcement purpose other than institutional security. And the Commonwealth doesn't make any claim that its search of these recordings is reasonable within the Fourth Amendment. It's clear that what the Commonwealth is doing in these cases is, in virtually every criminal case now, engaging in a fishing expedition by subpoenaing all of these telephone conversations of all of these inmates in the hope that they may find something incriminating to use against the inmate.
Is there any, I think the answer to this is no, but obviously across the country, these conversations are getting recorded, correct? I mean, in jails or prisons. So I'm just wondering, is there any case law developing anywhere about the use of, the subsequent use of these conversations?
Well, I'm not familiar with any case where the issue is presented as it is here with respect to the jail recordings.
You're not aware of any case that is presented one way or the other?
Correct.
And don't forget, we're talking here about plea-trial
Correct.
detainees, right? I mean, it seems to me that that's a little different than post-trial, because we have also said that once you have been convicted and found guilty, you give up plenty. Correct?
Yes, to a certain extent.
Well, you give up plenty. You may give up, for example, your Fourth Amendment right, because the prison authorities, can come in and search you at any time and so on and so forth.
Yeah, absolutely. But you only give up that which is necessary to maintain the security of the institution. All of the cases cited by the parties in this case for the proposition that jail recordings are routinely permitted all involve either recordings for institutional security, where there's a crime being investigated or something along those lines, or cases where under the federal wiretap law, the courts have said in this particular case there was consent under the law. But they don't raise and they don't deal with the underlying constitutional issue, which is, we think, presented here, and that is whether or not the inmate retains a limited protection, a limited privacy interest.
Haven't I read about cases where someone's in prison for one thing and they decide they're going to put a hit out on a witness or something like that, and they talk about it on the telephone and they get charged with it? How does that happen?
Well, it may happen.
Or they run drug empires from behind, locked up.
It may happen because these recordings are routinely turned over, but I don't think any of those cases have decided that that there is no limited privacy right of the inmates with respect to them. And we're not talking about a case where the sheriff may be looking through telephone conversations for institutional security violations and in plain view comes across evidence of a crime. I suspect in that case the sheriff might be authorized to turn that over.
I mean, so in Justice Ireland's example, if it's, forget running the drug empire through the jail, but a hit on somebody who's connected to that case, the sheriff may be able to turn that over,
Oh,
you're
sure.
saying?
I mean, if it's that, where you have an inmate planning a crime, either while in the prison.
But that's very impractical, because the sheriff has just admitted that they don't listen to these unless they already know something's going on, and the prosecution would only listen in terms of the case, of the immediate case. So you wouldn't find that out.
I think that's right, as a practical matter. That's they rarely, if ever, listen to these calls, and that's why when the district attorney initiates the search, that's the party doing the search. The sheriff, by making the recording for institutional reasons, is not essentially searching those telephone conversations. The other thing I want to mention briefly is that
You've written an excellent brief, and I apologize, but unless there's a pending question, we tend to say time is time. Thanks, Mr. Shapiro.